magandang Biyernes po sa inyo, aking mga kausapan. Please like, share, subscribe, and press the ting-ting bell button para ma-notify kayo sa aking susunod na vlog. Ito ang iyong abang lingkod, Usapang Batas with Attorney I. Ang rape ay labag sa batas na gawain na may kasamang pagtatalik na ginawa ng persahan o pananakot na sasaktan ng biktima. Ang rape ay problema ng halos lahat ng bansa. Ang saktong statistics ng rape cases ay medyo di kadaliang maitala dahil ang mga biktima ay pinipiling manahimik na lamang sa maraming dahilan. Pwedeng kahiyan, takot na gantihan ng rapist, at minsan takot sa magiging reaksyon ng kanyang pamilya. Kahit ano ang dahilan ng pananahimik ng biktima, ang epekto ay dumarami ang unreported rape, di lang dito sa atin, kundi sa buong mundo. Sinasabi na 35% ng kababaihan sa buong mundo ay nakaranas ng sexual harassment sa kanilang buhay. Sa Pilipinas, ang statistics ng krimen na rape ay ngayong taong 2022 ay 6.34% o 5,813 ang na-rape or ang insidenteng rape, mga kausapan. Medyo mataas ano? Pero hindi po tayo pumasok sa top 10 dahil ang nangunguna ay mga bansang Botswana 92.93, Lesotho 82.68, South Africa 72.10, Bermuda 67.29, Sweden 63.54, Suriname 45.21, Costa Rica 36.70, Nicaragua 31.60, Granada 30.53, at Saint Kitts and Nevis 28.62. Sa Pilipinas ay mayroon tayong batas, ang Anti-Rape Law of 1997, na binago ang definition ng krimen na rape ayon sa Revised Penal Code noong 1930. Ang mga sumusunod ay matatawag na rape. Article 266-A of the Revised Penal Code. Rape, when and how committed. Rape is committed, una, by a man who shall have carnal knowledge of a woman under any of the following circumstances: A, through force, threat, or intimidation. B, when the offended party is deprived of reasons or otherwise unconscious. C, by means of fraudulent machinations or grave abuse of authority. And D, when the offended party is under 12 years of age or is demented, even though none of the circumstances mentioned above be present. 2. By any person who, under any of the circumstances mentioned in paragraph 1 hereof, shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another person. Ang pagkakaiba ng Revised Penal Code noong 1930 at ang 1987 ay pinalawak ng huli ang definition ng rape at ginawa na itong crimes against person mula sa pagiging crimes against chastity. Sa binagong batas ay kinilala na rin ang krimen na rape sa mga lalaki. O mga kausapan, tama ang inyong narinig. Maaari nang ma-rape ang isang lalaki ng kapwa lalaki or both by other males or by females, as well as that both the victim and the rapist may either be male or female. Prior to the 1997 amendment of Act Number 3815 or the Revised Penal Code of 1930, male victims of rape were not acknowledged under Philippine law. Under Article 266-A of the law, defines rape by an act of sexual assault by any person, either by inserting his penis into another person's mouth or anal orifice, or inserting an instrument or object into the genital or anal orifice of another person. The 1997 amendment allowed the legal recognition of rape of males, both by other males and by females. Kaya lang, ang rape sa lalaki ay ayon sa batas ay rape by sexual assault. Maria Clara, ang tanong, ano kaya ang Maria Clara Doctrine, mga kausapan? Ang sagot ay, it is a relevant legal doctrine that observed by Philippine courts on abuse on women, including rape. It states that women, especially Filipino women, would not admit that they have been abused unless that abuse had actually happened, and that a woman's natural instinct is to protect their honor. Maria Clara is one of the characters in Jose Rizal's novel No Limitang Here. In Rizal's portrayal of the character, Maria Clara is reserved, shy, and has later on became an ideal in Filipino culture. So yun ang Maria Clara Doctrine, mga kausapan, pagdating sa rape. Well, karagdagan nga pala, the Women's Honor Doctrine was entered into jurisprudence in a 1960 case, in the case of People versus Tanyo, GR number L-11991, October 31, 1960. The Supreme Court held that it is a well-known fact that women, especially Filipinos, would not admit that they have been abused unless that abuse had actually happened. But the Supreme Court in its latest ruling said that doctrine has become a misconception. It added that doctrine puts the accused at an unfair disadvantage but creates a travesty of justice. In the case of People of the Philippines versus Jovi D. Amarilla and Jonah Dracho, GR numbers 225642-43, January 23, 2018, a ruling which convicted the two men for rape of a woman in Davao City and was reversed by the Supreme Court's Third Division due to inconsistencies with the woman's statements in regard to alleged rape and other evidences presented to the court. Nilinaw ng Korte Suprema na kahit naakwit ang dalawa at di ginawang sandalan ang Maria Clara Doctrine, this did not mean the abandonment of the doctrine. Contrary to speculations by critics of the ruling, applicable pa rin ang doctrine, mga kausapan. So sabi ng Korte Suprema, ang Maria Clara Doctrine ay applicable pa rin. Ang kasong rape, Article 90 of the Revised Penal Code provides a statute of limitations of 20 years from date of its commission. Ibig sabihin, kailangan maisampa ang kasong rape laban sa nang rape sa loob ng 20 years dahil paglampas ng 20 years and 1 day, ang pagsampa ng kaso ay paso na, mga kausapan, nag-prescribe na. Mga kausapan, mayroong bang bagong batas sa krimen ng rape? Ang sagot ay meron. Republic Act Number 11648 an act promoting for a stronger protection against rape and sexual exploitation and abuse, increasing the age for determining the commission of statutory rape, amending for the purpose Act number 3815 as amended, otherwise known as the Revised Penal Code. Republic Act 3835, also known as the Anti-Rape Law of 1997, and RA is amended, otherwise known as the Special Protection of Children Against Abuse and Exploitation and Discrimination. Sa batas na ito ay tinaasan ang minimum na edad ng sexual consent mula sa 12 anyos or 12 years old. Ito ay ginawang 16 years old o 16 anyos, mga kausapan. Yan ang bagong batas. The new law not only increases the age for determining statutory rape to below 16 years of age, but it also makes statutory rape gender neutral. Ibig sabihin, ang batas ay di lang pinoproteksyonan ang mga kabaihan, bagkos sakop dito ang mga minors, miyembro ng lesbian community, gay community, bisexual at transgender communities, mga kausapan. Sabi ng bagong batas, rape is committed by a person who shall have carnal knowledge of another person when the offended party is under 16 years of age or is demented, even though none of the circumstances mentioned above be present, provided that there shall be no criminal liability on the part of a person having carnal knowledge of another person under 16 years of age when the age difference between them or between the parties is not more than 3 years and the sexual act in question is proven to be consensual, non-abusive, or non-exploitative. Provided further that if the victim is under 13 years of age, this exception shall not apply. It added also, as used in this act, non-abusive shall mean the absence of undue influence, intimidation, fraudulent machination, coercion, threat, physical, sexual, psychological, or mental injury or maltreatment, either with intention or through neglect during the sexual activities with child victim. The law said, on the other hand, non-exploitative shall mean there is no actual or attempted act or acts of unfairly taking advantage of the child's position of vulnerability, differential power or trust during sexual activities. Attorney I, tanong, may isang 25 years old na babae, ito ay ginahasa. Ang mental age ng babae o ang kanyang pag-iisip ay yung pang 10 taong gulang lang. Maaari kayang kasuhan ang nanggahasa ng statutory rape, Attorney I? Bago ko sagutin ang tanong, ipapaliwanag ko na muna kung ano ang statutory rape, mga kausapan. Ito ay akto ng pagtatalik sa isang tao na under the age of consent. Sa bagong batas, ito ay under 16 years of age. Yan ang age of consent. Kasi hudang ang pagtatalik ay gusto ng babae o hindi. Sa statutory rape, karaniwan ng krimen ay nagaganap ng walang pamimilit o dahas, mga kausapan. Ngayon, alam na natin ang statutory rape. Atin namang sagutin ang tanong kanina. Sagot, oo, mga kausapan, kahit na 25 years old ng babaeng ginahasa, wala pa rin siyang kakayahan na voluntaryong pumayag sa panghahalay sa kanya. Ang krimen na nakumit ng rapist ay statutory rape, mga kausapan.
Time out muna tayo mga kausapan. Medyo nagutom si Attorney I. Mag-o-order muna tayo. Diyan lang kayo.
Halika, samahan niyo si Attorney I. Kain tayo.
Mga kausapan, salamat nga pala sa inyong pagsubaybay, sa inyong pag-subscribe at panonood sa Usapang Batas with Attorney I. Year 2 na pala ngayon ng Usapang Batas with Attorney I. Ituloy natin ang ating usapang kasong rape o criminal rape, mga kausapan. Republic Act 8353 or the Anti-Rape Law of 1997, as amended by Republic Act 11648, considers an act of sexual assault committed by a man against a woman who is under 16 years of age as statutory rape. Naisabatas ito noong March 4, 2022. Nakasaad dito na when the offended party is under 16 years of age or is demented even though none of the circumstances mentioned above be present. Dito pumapasok ang ating kasagutan tungkol sa ginahasang 25 years old na may pag-iisip ng isang 10 years old, mga kausapan, provided that there shall be no criminal liability on the part of a person having carnal knowledge of another person 16 years of age when the age difference between the parties is not more than 3 years, and the sexual act in question is proven to be consensual, non-abusive, and non-exploitative. Provided further that if the victim is under 13 years of age, this exception shall not apply. Ito medyo bago. Parang in-apply dito ang sweetheart doctrine na kung ang lalaki ay 16 at ang babae ay 16 din at napatunayan ng kanilang pagtatalik ay kanilang kagustuhan, walang pang-aaboso at nangyayari dahil sa kanilang pagmamahalan, yan ay walang rape basta ang kanilang edad ay hindi higit ng 3 taon ang pagkakalayo. Tandaan nyo, yan ay hindi magagamit na depensa sa kasong rape kung ang ginahasa ay wala pa sa edad na 13, mga kausapan. So ang sweetheart theory will not apply kung ang ginahasa ay 13 pababa. Ayon sa kataas-tasang hukuman, in interpreting the age of the victim in rape cases, the mental age of the victim matters more than his or her actual age in years, as explained by our Supreme Court in the case of People of the Philippines versus Rodolfo Diniega E. Espinosa, GR number 212201, June 28, 2017. Ponente as Chief Justice, who later became the Chief Justice, Diosdado Peralta. It is also a settled rule that sexual intercourse with a woman who is a mental retardate with a mental age of 12 years old constitutes statutory rape. In People vs. Kentas, this court held that if a mentally retarded or intellectually disabled person whose mental age is less than 12 years is raped, the rape is considered committed under paragraph 1D and not paragraph 1B, Article 266 thus A of the Revised Penal Code. In holding as such, this court differentiated the term mentally retarded or intellectually disabled from the terms deprived of reasons and demented, as under Article 266 thus A paragraphs 1B and 1D of the revised penal code. The court ruled that the term deprived of reason is associated with insanity or madness. A person deprived of reason has mental abnormalities that affect his or her reasoning and perception of reality, and therefore his or her capacity to resist, make decisions, and give consent. We are aware that the terms mental retardation or intellectual disability had been classified under deprived of reasons. The term deprived of reason and demented, however, should be differentiated from the term mentally retarded or intellectually disabled. An intellectually disabled person is not necessarily deprived of reason or demented. This court had even ruled that they may be credible witness, however, his or her maturity is not there despite the physical age. He or she is deficient in general mental abilities and has an impaired conceptual, social, and practical functioning relative to his or her age, gender, and peers. Because of such impairment, he or she does not meet the socio-cultural standards of personal independence and social responsibility. Thus, a person with a chronological age of 7 years and a normal mental age is as capable of making decisions and giving consent as person with chronological age of 35 and the mental age of 7. Both are considered incapable of giving rational consent because both are not yet considered to have reached the level of maturity that gives them the capability to make rational decisions, especially on matters involving sexuality. Decision-making is a function of the mind. Hence, a person's capacity to decide whether to give consent or to express resistance to an adult activity is determined not by his or her chronological age but by his or her mental age. Therefore, in determining whether a person is 12 years of age under Article 266-A-1D, the interpretation should be in accordance with either the chronological age of the child if he or she is not suffering from intellectual disability, or the mental age if intellectually disability is established. Yun ang bago mga kausapan. At sana mayroon kayong napulot na aral sa episode na ito. Salamat sa iyong pakikinig. May Attorney I, updated ka sa batas. Usang batas with Attorney I.